Welcome, everybody. Not much of a break, huh? Well, anyway, it's great to be here. So let me just get us started. So those who didn't see me earlier, I'm Jeremy Paul. I'm from Northeastern and a co-editor of the Journal of Legal Education. This panel will focus on new possibilities for legal education enabled by enhanced technology and unleashed as a result of COVID-19. Let me once again congratulate Tony Verona, Lily Levy, and their team for having assembled such a stellar lineup, and thank our partners at American University who will share the joy of assembling much of this work into a volume of the Journal of Legal Education. Our panel today includes a current dean, a former dean, a deputy dean, a law firm partner, a renowned blog editor, 2 professors with named chairs, a distinguished professor, a Dean's Distinguished Scholar, and above all, 5 very thoughtful and innovative teachers, scholars, and lawyers who will share their perspective on what is happening to legal education right now. Each speaker will have 8 minutes, so there's plenty of time left over for questions and answers at the end. You'll note that the chat function is disabled, and so to ask questions, you want to do so by entering them into the Q&A section, and these will be visible to me and the other panelists, and I will read them out to the entire audience. If you have a particular panelist to whom your question is addressed, please write that in the chat. Our session will open with remarks from Leonard Baines and Michael Frumkin, each of whom will set the stage for considering our current conditions from the perspective of long-run issues within legal education. Then we'll hear from Charlton Copeland and Glenn Cohen about innovative programs. Each has spearheaded that attempt to welcome more people into law school in ways enabled by technology. And finally, Kathleen Sullivan will comment on the panel from her perspective as a former dean and now as a prominent attorney who represents universities in many contexts, including those created by disputes engendered by COVID-19. So let me then get right to introduce Leonard Baines, who will kick off our panel. Len is dean and professor of law at the University of Houston Law Center, where he has been since August 2014, thus already outlasting the average decanal tenure. Before Houston, he taught for more than a decade at St. John's and served in private practice as an attorney at the FCC. Back when he was earning an honest living as a professor, he specialized in communications law with an emphasis on business and diversity issues. Len has been a leading innovator in diversifying the legal academy for as long as I can remember. And for me, that's a long time since I recall his speaking in Hartford while I was dean at UConn. I am proud to turn the microphone over to him. Go for it, Len.
So what I want to talk about is sort of how we got here, and really got here from the pandemic, and talk a little bit about that. So we're here because of the virus. You know, that's why we're online. It's really important for us to recognize that. And the virus has taken a toll. You know, we have almost 5 million infections in the United States, almost 160,000 deaths, about 75,000 infections per day in the United States. And the infections in Texas, my home state, and Florida have ranged anywhere from 5,000 to 15,000 infections a day over the past month. So it's a real health emergency that we're experiencing. The health emergency has had a disproportionate effect in terms of mortality on African Americans and Latinx Americans. It's also had a significant economic impact, and this really derives from the fact that we have sheltered in place for quite some time. There have been maybe 40 million jobs that have been lost. The GDP for our first quarter on an annualized basis declined 5%. The GDP for the second quarter dropped 32.9%. The stock market for the first quarter had dropped into 20%, but now has increased. Part of that, the increase and the stability of the market at the moment is probably attributable to the stimulus. A lot of this has created a lot of uncertainty, especially economically. And the recovery that we may have is really tied to fighting the virus. So some economists have first said, well, maybe we'll have a V-shaped recovery because we shut everything down and we'll open back up and everything will be back to normal. Others have said maybe it'll be W-shaped, that every time you have embers or flare-ups or waves or whatever you want to call them, that we may go back to sheltering in place and the economy may falter, and then maybe you'll then go back up again. Others have said it really depends on what we do with this virus and how long it takes us to deal with the virus. And it may be L-shaped, meaning that we'll be down at the trough for quite some time. And all this has affected higher education significantly. So Moody's downgraded higher education's rating from stable to negative. They said that there's unprecedented enrollment uncertainty, especially with online. The fear was students might not show up. They may take a gap year at the college level or the law school level. And the university's budgets are stressed responding to the virus. And let's talk about universities' budgets, which affect law schools, because many times, many faculty members only see, or may only see, the correlation between the earnings or income of the university or the law school with the tuition dollars from students. But many major universities have a lot of other ancillary income streams, from sports and athletics, which has been shut down to some degree. Dorms, you probably hear a little bit more about that with respect to students not staying in the dorms and being sent home. And if you have online, you may have fewer students staying in dorms. Parking fees, meal plans, rental from shops and eateries that are on campus, and foreign enrollment has been down, and many universities have major foreign enrollment. And because of the rhetoric over the past few years that's been anti-immigrant, and also with respect to this recent situation with international students, it's very, very hard to attract international students to the United States again. For state institutions, revenues are down because earnings are down. Individuals' earnings in the state are down, which leads sales tax revenues to be down, state income taxes to be down, and for states like Texas, which rely heavily on oil prices, they are down. As I mentioned, the stock market dropped 25% in the first quarter. It's currently back to sort of where it was, but we have to keep an eye on it because it affects annual giving, affects any endowments you may have, and the stock market has gained ground, as I said, but it's still a great deal of uncertainty. So this is like, I don't mean to be doom and gloom, but it is sort of where we are, and it's a situation that many, many universities face. This is just a catalog of some of the newspaper headlines I've seen over the past few months of major state universities and other universities have indicated what their budget deficits are. And as you can see, many of them are in many, many million-dollar figures. Some have almost in billion-dollar figures. Those universities that have their own hospitals are most at risk with respect to all of this. And even with the private, some of the private, very highly regarded universities, they've indicated they've had freezes of procurement, hiring, or salary reductions. So what does this mean for law schools and universities? Well, it means, at least in the short term, there will be fewer funds available. We have these dean webinars regularly, some Chatham House rules, but some of the folks who spoke said recruiting scholarships may shrink. Some have said that faculty research grants may shrink. There are faculty, staff, and vacancies that may remain unfilled. Will need to be, as we see, more virtual and digital anyway because of the virus. We need to be more economical, need to be more creative, need to raise more money for philanthropy, but that's hard with the uncertainty with the stock market. But we need to focus on our core mission with fewer resources. So what does this mean with respect to online? I think to a large extent, it means we have to embrace the online world. That I don't know whether we're going to go back. My associate dean and I joke. He says, oh, we'll probably, there'll be maybe a 10% change in things once we get back to normal. And I estimate maybe 40 or 50%. A lot of it, I think, is because I've seen, at least with respect to these other things that we do, we've been doing them online and we've been doing them effectively. We've had 4 faculty meetings virtually at University of Houston. I can't imagine that we won't, we will. I can't imagine we'll have a faculty meeting in person probably through the end of this year, maybe the whole academic year. We've been doing, as University of Miami is doing, we've been doing JLE and other events online and having very big audiences. We've had other conferences also online that have attracted worldwide attendance in our energy and environmental law space. We've done our Dean's Award ceremony for students and faculty recognized for their accomplishments. We did that online. We've had career chats with students about their development and guidance with respect to COVID. You know, we organized with the other 9 admissions officers in Texas a webinar panel for admitted or prospective students. And what all these things do, and we also had a swearing-in ceremony for newly minted attorneys that was online. We've had an alumni annual meeting online. And what all these things do, all of these other kinds of things that may be non-classroom related things, what they all do is, for several things as a dean, I like them for several reasons. One, they're cost effective. If I'm having this event, I don't have to fly anybody in, I don't have to provide food, I don't have to provide housing, a hotel, I don't provide any of that sort of stuff, number one. Number two, I'm able to tap into people I would not normally get, because spending an hour out of your time to be on a panel, or 2 hours, is a lot easier than flying somewhere, staying overnight, etc. You lose the networking opportunity, but it's a lot easier. And with this alumni annual meeting that we had about 70 people. It still was not as big as it could be. Half of the people were from outside of Houston, and half of them were people that we had not connected with in a while. And I just say to myself, wow, these are individuals who are alums that are prospective donors, they're prospective employers. We're engaging with them in ways that we would not have been able to do through this online platform. So for a lot of these things, I think that we will, I can't say we will never go back, but I think that this is sort of going to be the wave of the future for a lot of these other sort of related, non-classroom related things. But also one last thing, and I know we're perfect time and I hope I don't go too over, but I just want to raise this as all. I think that the virus, we talk about flattening the virus, flattening the curve with respect to the virus. I think that COVID, to a large extent, has actually flattened some hierarchy and privilege. And I'll just briefly discuss it. And I think part of it is because of the budgetary considerations. Will force us away from this hierarchy to some degree. We'll focus more on our core mission of educating students, sort of generally. And you see it with pass-fail grading, legal and diploma privilege. The last 2 points I want to make. With pass-fail grading, I've been dean now for 6 years, going into my 7th year. And there's a provision in the bylaws that allows faculty members, like 6 faculty members, to get together and call a meeting. They called a meeting. That was the first time in my 6 years, and first time in probably history, recent history, that the faculty members wanted me to call a meeting about pass-fail grading. When they approached me, like, really, they want to go to pass-fail grading? I was surprised. And it passed almost unanimously. There was no voice for the status quo. It was fascinating and amazing to me. And the question is, like, once you go down these roads, the question is, like, will you ever be able to go totally back? So, like, we experienced Hurricane Harvey in Houston, and we have students who are graduating today who experienced Hurricane Harvey. We did nothing for Hurricane Harvey. We didn't do pass-fail for Hurricane Harvey, even though a lot of people were affected. I was at St. John's during 9/11. It was an awful situation, awful experience for all of us. We did nothing in terms of pass-fail for 9/11. So the question really is, will we ever really be able to go back when there's a major crisis? And the same thing with diploma privilege. I've seen so many deans on the listserv in their statements, in their correspondence to Board of Law examiners favoring diploma privilege. I would have never expected that to happen. But what I see is that this situation is certainly unique, but it's also making us really think what our core principles are. And it basically is making sure that we are able to make sure that our students are safe, that our students don't have inherent advantages. Because one of the things that my faculty said over and over again is that, and the students said to us, is that, those who have, very privileged existences, these things won't matter to them as much as those who may have to work and have family responsibilities. So I'll stop there. I'd love to have more Q&A, but I think that this is a real sea change in legal education for a variety of reasons. And I'd love to hear some thoughts and questions and hear from my other panelists. Thank you so much.
So I love how you started with challenges, the economic and health challenges, but then had a nice upbeat view about the kind of changes that you thought would take place. Okay, our next speaker is Michael Frunkin. Michael is the Laurie Silvers and Mitchell Rubenstein Distinguished Professor of Law at the University of Miami, where he joined the faculty after federal clerkships and time at a top firm in London. The world knows him as one of our nation's leading scholars studying internet governance and the multiple subfields of law created by the advent of computers. Many of us revere him, however, for his role as the founder and editor-in-chief of Jotwell, a legal blog shortened from Journal of Things We Like a Lot, one of the most lively and informative places to learn about the law. For many years, he has been predicting radical disruption of legal education from internet teaching, and he will talk to us now about why he may have been right all along. Michael, it's the hour of videos.
Thank you very much. I'm going to try to share my screen here, and if all goes well. So I'm calling this talk the Virtual Law School 2.0 because a very long time ago, 20 years ago and more, I gave a talk at the AALS, which was called the Virtual Law School, or How the Internet Will De-Skill the Professoriate and Turn Your Law School into a Conference Center. And in that talk, I made a bunch of ambitious predictions about what the internet would do to law schools, very much what it was doing to the record industry and many other industries as well. After all, the cost of copying digitized materials was almost zero. Why not do this to law lectures? And if we did it to law lectures, what would that do to law teaching and law schools? Well, we'd be moving into distance learning, synchronous learning, and especially asynchronous learning. It's what I call real virtual learning. It's the way you tape it. And that seemed to offer the potential to teach more things, teach them better, and this is where the deans got excited, save money. The lectures will be, I imagined, offered by name brand academics, right? So Sunstein will be everywhere. Courseware could be reused for several years in many subjects. This worked for standard subjects like torts and contracts, but I thought it would also work very well for specialist subjects. Students would get an opportunity to take low enrollment subjects otherwise not offered in a small law school and even in a large law school. However, we need people to do some of the grading. And that new class of TAs, what I then called Arthur Miller on a disk, would be those people we used to call the faculty. And over time, deans and especially boards of trustees that are always looking to save a buck and destroy tenure would replace the professors with contract instructor TAs who cost less money and worked more hours. So how's this going to work? Well, I thought that the schools which invested, and it's expensive to start out, invested in advanced courseware, we get first mover advantages, they get to set the standards, they get branding advantages, just like in the software market. And indeed, I also imagined that some top schools would open virtual extension campuses, maybe on the executive education model, where students would come to campus for a week or two, a year or a semester, and otherwise do everything online. Meanwhile, they'd be creating courseware, which other schools would get to buy from them. And we'd have a new class of low-price schools that were all virtual and bought in all their content. Now, if that happened, traditional method schools would face terrible price and student quality competition. They'd face price competition from the low-price online-only or online-mainly schools, and they'd get student competition for good students from the executive education campuses from the brand name schools, right? Some people would choose to go to the Harvard Extension campus rather than come to Miami. A mistake, but they'd do it. And schools in the middle, especially private law schools, would then get squeezed from both sides. And yet, none of this happened. I was completely wrong. Why is that? Well, it turns out there are 5 reasons. The first was that the ABA had very restrictive rules, which made distance learning impossible if you wanted to be an ABA accredited law school. And they only very gradually relaxed those. The major relaxations were in the last 5 years. But the really big one is coming down the pike, perhaps in August, when they're going to take the lid off and allow a great deal more distance education than ever before if the ABA approves those changes. But so far, the ABA rules were a big problem. An even bigger problem, in my opinion, I think most people would point to the ABA, but even bigger problem, in my opinion, was that the software was terrible. Right? What were the leading examples of the software you could use to teach online? Well, there were these MOOCs, these massively online courses, open courses, and Second Life, virtual worlds that didn't work very well. And they were all terrible tools for teaching law courses. And so too were plain old taped lectures. You can't do soft Socratic, much less real Socratic. Students get bored, they don't like it. It just didn't work very well. There are also some legitimate, I think, pedagogical concerns, right? Faculty thought the quality would suffer without a chance for students to ask questions if they got lost. And they worried a lot about the intellectual agenda for the nation being set by a small number, excuse me about the worseness, of national name brand schools or scholars. Furthermore, at the time we worried a lot that students would need to learn to work together to network, and networking on the network is something we hadn't figured out how to do, and they'd want to socialize too, and that was also something we didn't know how to do online. A fourth reason was that the early movers turned out not to be the big brand name schools, right? There was no equivalent of MIT in the legal world. Instead, it was Concord Law and Phoenix U that were doing the well-known online distance learning, and they gave it a bad name, a bottom-feeding name, and schools didn't want to go there. And last, and not least, it turned out that distance learning, real-time, and even virtual universities, asynchronous, didn't save nearly as much money as we thought. Turns out that doing it right online has very high fixed costs in equipment, in training instructors, and in training the support staff. And that distance learning, a synchronous class, doesn't really save you much money. It might even cost you money. Yes, you can put on more classes to your students by buying in classes that otherwise would have very bad ratios, but you pay somebody else for those classes. You don't make much off it, if anything at all. And as distance learning is live, if you're the provider, there's some limit to class size when you host, unless you have TAs, which are then a variable cost, and the class content is not reusable. Now, the virtual taped content has slightly different economics, but they don't save as much money as hoped either. Yes, the recorded content, the fixed cost, is reusable. As I said before, it can date quickly. And how do you do a pocket part for a recorded lecture? We haven't really figured this out yet. You can do fancy editing tools, but that requires people with skills. And then it turns out that law professors are very jealous of their IP rights and they want residuals. You still need TAs, a variable cost to run the discussion sections, to grade the quizzes, exams, and papers, and so on. And what's more, it turns out that even your distance students want ancillary services as much as in-person students, if not more. They want placement, they want counseling, they want disability support, and all the rest of it. Maybe this time is different. Maybe the predictions I made 20 years ago are actually right for the moment. As I said, the ABA is in the process of considering a major relaxation of its rules. And I think a lot depends on how long this pandemic lasts, right? If a vaccine turns up in January, we all say we're going back to the old ways, maybe it'll be another 20 years before I'm right. But if it lasts 2 years even, law schools are going to have spent, this is a typo, will have spent this on costs there in training and equipment. And we'll also be teaching students skills they need about online delivery of services, right? We just had the first Zoom jury trial in Florida last week. So we're going to need to teach our students how to do that. And you can certainly teach that online at least as well as you can in person. What's more, the vendors are going nuts now that there's this huge demand, and they're building all these new tools, and maybe finally we'll get some tools that actually make online teaching easier and we'll learn to do it better. I admit I'm not there yet, but I'm hopeful. And what's more, as students come through the pipeline, having had a lot of online education, they may be used to it and demand an online option. And if you look at these lawsuits that we're going to hear about later, they may also want a big discount if they're online only. Now, there are some counter arguments, but I think they're a lot weaker than they were 20 years ago, right? The ABA thing is gone. Some of the economic stuff is gone because the sunk costs are spent, but some things still remain. And the number one is that teaching is a human process and that we just won't figure out how to preserve the human aspect when we move online. And as people mentioned before, it's even easier for students to shop and trade stocks during class than it is now. Although if you've ever wandered in your classroom and looked at what people are doing on their screens, it can be a bit of a shock. It may be that students will value, will value the human elements of the educational experience enough to keep law schools and university generally going. Students might want their campuses back, but then the question is, will they pay a premium for them compared to what might be the cheaper online option? Yes, drinking alone is much less fun. Networking via Ethernet is different, maybe hard, but how much can you charge for all that? And then, of course, if the students who are learning online for some reason some people learn better online, probably. Learning styles differ, but some people learn worse, and people may not know which they are, and some people may make the wrong thing. Other people may, even though they know they're better off in person, may feel it's just too expensive. If there's a cheaper option, pick online. And also, as prices go down, economics suggests we'll get more students. So we may get a new class of people who may or may not do as well on the bar. So there are lots of stories you can tell in which the bar pass goes up. There are lots where you can tell where it goes down, and there's some where you can tell where it doesn't change much. If it goes down, the ABA, pressure from state Supreme Courts, is certain to do something. Weirdly, maybe perversely, if scores go up, the ABA might also step in, again with pressure from state Supreme Courts, seeing a chance to raise scores for everybody to improve the quality of the bar. And let's absolutely not talk about reducing the number of lawyers and keeping salaries up, because that would be illegal. So who wins and who loses from all this? Well, in my view, the winners are the elite law schools that run virtual extension campuses and or sell brand name courseware to the law schools. The winners are low price law schools that buy in all their content, or at least as much as the ABA will allow them to do so, and thereby try to minimize their costs. And the losers are all the law schools in the middle. 20 years ago, I said public law schools will be okay because the state legislatures would keep them afloat. Now I'm more pessimistic about that because states are broke, and also because public law schools have more and more dependent on tuition revenue. So I think they're in the same boat as the rest of us to a very great extent. The losers are non-elite faculty. That'll be people like me who get demoted to TAs for the courseware and generally de-skilled and or replaced with less expensive contract TAs. And then we have the big unknown. Are students winners or losers? Well, they win if the quality is good and if the prices are low, but we don't yet know that either of those things is going to be the case. Right? If they are, students are big winners and maybe justifies the losers. If they're not, society may have a problem. So in conclusion, I think I was wrong, at least over-enthusiastic 20 years ago. Can't argue with reality. But this time I'm going to tell you will be different, especially if the pandemic lasts more than a very short time, I'd say 2 semesters. And online teaching becomes a new normal instead of the new abnormal. So see you in virtual reality in 20 years, and there's a 57-page version of this if you're feeling really sleepless at night. Thank you very much.
Thank you, Michael. Okay, so our next speaker is Charlton Copeland. Charlton is Professor of Law and Dean's Distinguished Scholar at the University of Miami, where he's been since 2007. He's a prolific scholar on federalism issues and has also explored in writing the intersection between law and theology with particular reference to same-sex marriage. More recently, he has turned his attention to issues of race and its relationship to American political and legal institutions. This has perhaps sparked his interest in a pipeline program he will talk to us about today. Prior to Miami, Charlton taught at Northeastern, was an associate in an elite DC firm, and clerked on the Constitutional Court of South Africa. Charlton is also a winner of teaching awards for his contributions to student advancement, and so I know we'll all enjoy hearing from him today. Charlton, you're up.
Good afternoon. I just want to thank Jeremy and my co-panelists and the organizers of this symposium. So I feel like we are in Lynn's W-shaped curve. I'm going to try to bring us back up the roller coaster a bit on Michael's hopefully not so prophetic note, but there is a bit of bad news. That is to say, to think about the state of affairs with respect to the diversity in America's law schools, and if we take Professor Sunstein's keynote seriously, we ought to be concerned about that for any number of reasons, not the least of which is their impact on the intellectual engagement in our classrooms. But the state of the world pre-COVID, the state of the world that we woke up to in January, was at least defined in some respects by a December 2019 ABA report that released information with respect to student enrollment data. It touted the fact that student enrollment had increased in law schools by about 2%, but that minority enrollment in law schools had declined by 0.2%. And that was a multi-year decline for minority students while an overall increase was taking place. We know how difficult it is to yield the same numbers of minority students a study of the 2016-2017 admission cycle reported that it took 1,960 applicants to yield 1,000 offers of admission to Black applicants, compared to 1,200 applicants for 1,000 offers of admissions for white applicants. Further, studies have reported that while 49% of Black applicants received no offer of admission, 33% of Latinx students received no offer of admission when they apply to law school. The overall percentage of that non-offer is 25%. Further, between 2009 and 2016, the Harvard Law School's Black student enrollment in their first year class went from 67 students in 2009 to 31 students in 2016. Those numbers more recently have started to reverse a bit, but they are still significantly lower than the 67 students that enrolled at Harvard in the fall of 2009, again, in the midst of a recession. Further, data with respect to non-transfer attrition shows that while white students constitute 62% of 1L students in 2016, they made up 49% of 1L non-transfer attrition. And by non-transfer attrition, we mean students who simply did not continue into the second year and did not transfer to other law schools. Minority students, by contrast, represent only 30% of the 1L enrollment, but 44% of 1L non-transfer attrition. Those numbers are largely driven by Black and Latinx students who do not continue on to the second year. The justifications or explanations rather for non-transfer attrition are largely academic. Some of those numbers can be explained by financial hardships, but they are largely the result of academic dismissals. And so I want to touch on a couple of things that Dean Baines mentioned, right? That is questions about the role that U.S. News and World Report plays and issues around LSAT and issues around the bar that, that my colleague Michael Frumkin has also touched on. That is, in a post-COVID world, if we think about some of the transformations that Dean Baines has mentioned, and if those changes become longer lasting, right? And one of those that hasn't yet been mentioned is the move away from LSATs by law schools, allowing a greater range of standardized tests to be submitted or substituted for the LSAT. More recently, right, the LSAC, and I know we'll hear from Kelly Testi on a subsequent panel, but the LSAC has moved to a more flexible LSAT exam. What that entails is not altogether clear, but some of these changes and the potential for long-lasting changes in the bar exam and the LSAT may also put some, relieve some pressure that has been explained or cited to rather as a source of diminished minority enrollment, right? That is that law schools, in an effort to maintain their rankings, pursue high LSAT scores, pursue students who they think are going to do better on the bar exam, and those pursuits diminish the number of minority students enrolled in 1L classes. And again, if we see long-term transformations in a post-COVID world that are the result of what we've done in this moment, then it might relieve some of those pressures. Some of the other pressures, or some of the other sort of responses to that, are pipeline programs. And I'm a member of this panel only because in the midst of COVID, we decided to do an online-only summer program for high school and college students. And the program allowed us to serve on the college side about 100 students, up from a goal of 30. And about 40 high school students. We ended up on the college side despite the fact that we wanted only 30 initially, with 5,000 applications, again, for a 3-week program for which there was no tuition. The program focused primarily on core 1L classes, allowed the students to do a mock trial for the high school side and a moot court oral argument for the college side, and allowed students to take one elective in the 3rd week. That is distinct from other quote unquote pipeline programs, both at the high school level and at the college level. Most pipeline programs are residential programs. Most pipeline programs charge some level of tuition. Many of them give extensive financial aid, but even the financial aid doesn't cover travel costs, right? And so there are still resources that must be expended by students to actually live in and on campus and to get to campus. And so we think that there might be an opportunity here, a transformative opportunity to rethink pipeline programs. Again, to go back to Dean Baines, the pipeline program that we ran was virtually costless. The cost of that program primarily was to hire students who served as Dean's Fellows. For the students in the program, professors volunteered their time. They taught 2 courses over a 4-day period and 4 hours. And I think this opens up the possibility of a much wider set of pipeline programs. While I don't think, and I certainly hope that virtual pipeline programs are not replacements for in-person, on-campus, boundary expanding programs, right? For students who have never left their hometowns, I think these programs can be quite transformative. We had in our program students who had small children. We had in our program students who worked in the afternoon. We had in our program students who lived a significant distance away from Miami. And so the cost of coming to Miami, the cost of Miami hosting those students would have been largely prohibitive, right? We've thought about and talked about the possibility of doing a program like this, but when you think about the cost of housing students and when you think about the additional cost of feeding students, those costs made that kind of endeavor rather prohibitive. Nevertheless, right, we were able to serve 140 students on the college side, 40 students on the high school side, for a budget of something like $10,000. That's, again, we haven't done much in the way of thinking about what impact we've had, but for my mind, that's a big bang for your buck in terms of expanding opportunities. And one of the things that I think we did, and one of the things that I think we will want to think about is most programs of this sort that law schools run are pre-1L programs. Many of the experts suggest that those programs come too late to help students. Why do they come too late? They come too late to help students actually pick the sorts of courses as undergraduates that they ought to be taking for the kinds of skills we need them to know to do really well in law school, right? They need to understand the importance of history. They need to understand the importance of reading. They need to understand the importance of economics, and programs that come earlier in their college careers that allow them to see the diversity of law and the extent to which law relies on other fields tends to have greater success. And so I'm gonna stop there and hand it over to Glenn Cohen, hopefully keeping us on the upside of the curve. Thank you.
We're doing the best we can on time. All the panels have been so interesting that I've been reluctant to cut anybody off. So Glenn Cohen is the James A. Atwood and Leslie Williams Professor of Law, Deputy Dean and Faculty Center of the Petrie Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School. He is one of the world's leading experts on the intersection of bioethics and the law, as measured both by a stunning array of serious scholarship, 15 books and more than 150 articles, and countless media appearances on major television networks and the world's leading newspapers. He's a pioneer in online teaching, having taught a course through Harvard X on the law and ethics of reproductive technologies to more than 25,000 students. Before teaching, he was an attorney at the appellate staff of the Civil Division of the Department of Justice, and he's the founder and leading force behind Zero L, a bridge program that acculturates students to begin law school. Thank you so much, Glenn, for taking time to be with us today. The screens are yours.
Thank you very much for having me. And I'm going to switch to screen share in a minute. But before I do, I just want to say, one thing you didn't mention to me is I'm a proud first-gen student. And the reason why that's relevant, I think, is neither of my parents finished high school. So I came to law school really not knowing what law school would be like. But my mom, I think in part because she had not finished high school herself, really overdosed on learning psychology and going to a bunch of lectures. And she used to always reference this one lecture she saw where the learning psychologist said, "Why do parents think that learning ends at 4 p.m.? And that same insight, when class gets out, that same insight I think is being really brought home this year to law professors. Now we've always known this in the sense that our class, the time we spend in our class is not everything. We've assigned readings, we have office hours and the like. But we've really very much as law professors focused on that time period. And I think what's disruptive in a positive way about the online experience is causing us to be much more purposive about the rest of the time our students are spending learning. And the metaphor I use when I train faculty to transition their courses online, and we're going to be 100% online in the fall, is that of a dinner party. When you throw a dinner party, you always serve as the main course, the thing you've done before and you're really good at. For me, that's, I think, Socratic teaching. For others, it might be lecture. But what online learning lets us think about is what can you pair as an amuse-bouche, an appetizer or a dessert? Maybe that's discussion groups. Maybe that's pre-class submissions. What can be the wine pairing during your excellent dinner course? Maybe that's polling, or maybe that's a breakout session. And the online period that many of us are in now and experienced in the spring is causing us to think about not just doing this online, but bringing back home. And this same idea I want to suggest is not just for an individual course, but thinking about the entire curriculum. So of course we've heard the phrase flatten the curve quite a lot with a negative connotation, but I think of this in some ways of flattening the curve of the curriculum. Rather than assuming we have these 3 years of law school and in classes when students will get everything, what if we thought about the period before law school, the periods between the years of law school, and even the periods after as part of a legal education? What if we could create something that made students feel on day one prepared, excited, right? And that's what we went through with the Zero L program. I'm going to show my screen now. This is the first, I'm going to try to actually also share audio, and this is the first time I've ever tried to do both at once, which is probably a disaster waiting to happen, but let's see what happens. Got to go into this with some excitement. Okay, and someone tell me if when I play audio you can't hear it, because I don't want to look too much like the fool. So basically, my dean challenged me to try to build something for our law school, for our own law students. And the goal was to make every student feel on day one like they were prepared without preempting what it is that faculty want to teach. So the idea is, can we bring you into law school feeling like you can be your best self, feeling like you are with your peers and ready to learn without getting our torts, property, civil procedure professors angry at us that we're stealing their thunder. When we first designed this for our own students, we then came back and we saw it was such a great success with our own students. We went to 4 partner schools, Baltimore, BC, Northeastern, and Seton Hall, to see how it worked with their students. They gave us very positive feedback, and this year we rolled this out to any law school in America that wants it. The dean decided because of COVID, we're just going to make it free to anybody who wants it. As of now, I believe it's about half of all American law schools are running it right now, so I'd love to hear your experience. But the course, the Zero L course, is basically arranged around 7 big modules. And the idea here is let's have people center their learning, have a little bit of exploration and freedom to explore, but let's try to group the materials into 7 parts. And most of them follow the routine I'm going to show you in a second, but I just want to highlight a couple that are a little different. One is how to read a case, understand precedent. Here we assign them a case and we take them through 11 very short videos, 12 very short videos, things to pick out in a case. We challenge them to try to pick it out in the sample case, and then we have them try it and then see a reveal of what the answer is. We've also encouraged schools to incorporate this as part of their orientation, to supplement it, and to try a different case with the students now that they've had this training once. The other is this test drive, applying what you've learned, where we try to transition from this course to that first day of classroom by giving people a taste of the kind of back and forth you might hear in class, and also introducing them on how to brief a case. Okay, so let's say I went to a preview of your 1L course. That would take me here. This is the module. In the module, you get a little bit of an opener describing what's in the module, a little bit of a how-to to navigate it. And again, we want to encourage students to focus on that which is going to be helpful to them depending on what courses they're taking in the fall. And then if you jump to one, let's do a historical overview of the Constitution. This is where it would bring you. I'll drag this down for a sec. It would bring you to a lesson page. This is the lesson in question. And we get a little description of what the lesson introduces. We've followed podcasts here in telling you where you'd find various parts of the video, knowing that some of our students will want to start and stop, and some will want to go, all right. And here's where I'm going to push play and pray to God this works. Let's see if you hear audio.
Guns, gay marriage, abortion, Guantanamo Bay. Each and every one of these topics has something central in common in the United States. That thing is the Constitution. In the United States, as the French traveler Alexis de Tocqueville noted already in the 19th century, every major topic has a tendency to become a question.
Okay, that's enough about Noah. I don't want him to steal my thunder. He's a very good teacher, so I have to be a little bit careful about showing too much of him. But after you go through these lectures, and sometimes here we've got 2 of them, we then bring students to a set of vocabulary. They have great vocabulary flashcards. And then finally, we have a quiz for every section. We tried very hard, and this was feedback we got from our students because we focus group with this with different groups of students, with people who had taken the course. They told us, my first experience of law school shouldn't be me failing something. So we tried to make these quizzes non-evaluative. They tried check-ins. They're ones that most people are supposed to get right. And we have various formats, but this one is just matching what particular amendment did with something like this in a drop-down. Okay, I'm gonna stop sharing screen now. So this is just an example of something that we did, but I think the larger genus and what I want to emphasize is the idea that our time with our students is incredibly precious, right? I want every minute I spend in synchronous space with my students to be maximized, that I'm always thinking to myself, why am I doing this synchronously? What this experience of the pandemic is showing us, both for the curriculum and for individual courses, is that there are parts of learning that can take place outside that synchronous space. And if you are purposive, if you think about this as a pedagogue, you can figure out with the right amount of effort and the right amount of resources, I don't want to diminish that, you can figure out a way to enhance learning and make that synchronous time really go well in a way that is enhanced by this rather than detracted. That's all I want to say. Thank you very much.
Thanks very much. Questions are pouring in, but we have one more speaker who last and self-evidently not least, we have the privilege of hearing from Kathleen Sullivan, now a partner at Quinn Emanuel Urquhart and Sullivan, LLP, where she chairs its national appellate practice. And Kathleen is also the former dean of Stanford Law School. By any measure, she is one of the most successful and most skilled lawyers in our country. I still remember her win the Ames moot court competition back when we were students many years ago. So it's no surprise to me that she has now argued 11 times before the US Supreme Court and argued cases in nearly every circuit and been named to pretty much every list of the best lawyers in America. She also wrote the canonical article on unconstitutional conditions, and her current practice includes representation of US universities in litigation matters stemming from the COVID-19 pivot, which I know will inform her remarks. Kathleen, it's an honor for all of us to have you here, and we look forward to your remarks.
Well, thank you so much, Jeremy. And I want to just begin by thanking the university and the journal for including me in this wonderful panel, and especially my dear law school classmates, Lily Levy and Jeremy Paul. I think I owe my entire career to having sat next to each of them in my first year of law school in one class or another. So thank you, Jeremy, Lily, fellow panelists. So I'm going to shift to the question of who gets to decide some of the educational and pedagogical questions that the panel has given such a wonderful discussion of so far. Is it going to be deans and professors or accreditation agencies like the ABA? Or is it going to be courts sitting in civil litigation? And my launching pad for discussing that question is the set of lawsuits that have been filed in the wake of the shift to online education since March of this year. In the wake of COVID-19 and the concern about spread through in-person education, there was a rapid transition, often at great expense and disruption, to continuing students on their path to their degree, uninterrupted in schedule, and doing so through online substitutes. There are now 220 lawsuits against 145 different universities or university systems alleging some combination, varying with the case, of breach of contract, unjust enrichment, or conversion on the basis that tuition was paid in advance under a contract or quasi-contract that entitled one to in-person education that wasn't delivered. Now, while many schools have provided partial refunds of fees, separable unbundled fees like parking and dorm residency, most universities have taken the view that retrospective tuition refunds are beyond the pale. Now, I have the privilege, our firm has the privilege, along with some of my colleagues in our education group, of representing now 10 different universities in 18 different lawsuits, universities including Duke and Johns Hopkins and Brandeis, a number of others. And so I've become accustomed to coming up with some of the strong defenses that have been leveled against these claims. And I want to discuss two of them because I think they give us a window to the topic that the panel has discussed. The first is to say, well, there really isn't a contract for all of those implicit, intangible adjuncts to your core curricular delivery of a credential. You bargained for the main course, Glenn. I'm sorry, you just didn't bargain for the amuse-bouche and the wine pairing and all this other intangible stuff that goes with it. Now, the claims assert that there was an express or an implied contract asserted through admission materials and online websites and student manuals and teasers like the ones that Glenn just showed us on the website, that there's an implicit invitation not just to come get stuffed full of learning, but to have the pedagogical excitement of in-class discussion, the late night hallway class chats, to quote from some of these complaints, the kinetic energy of connections forged, the creativity sparked, the ideas born, the community of support. Now, in defense against claims that the contract was broken with respect to those promised aspects of one's in-person education, the universities, of course, assert, and we have done so publicly in motions to dismiss, that there was no contract for those things. There was no express contract for those things. There was a contract to pay tuition for a certain credential delivered on a certain schedule, and no one disputes that the universities and law schools have performed heroically to try to deliver substantial performance of that actually bargained for contract. The second defense, though, and here I think there are a lot of interesting questions that connect back to the rest of the panel. The second defense is to say, independent of whether a contract was formed, there's either a kind of immunity or an affirmative defense that sounds either constitutionally in the form of academic freedom or sounds in the kind of common law embodiment of academic freedom called the bar on educational malpractice. Most states have some version of a common law kind of doctrine of educational malpractice that it's not a cognizable tort to say that I was denied the, to quote from some of the case law, I was denied the sufficiency of the educational process I was promised. I was denied the nuances of educational processes and theories I was promised. I was denied an education that was sufficient, rigorous, or adequate to my goals. Both in tort and in contract and in quasi-contract, many states, some states are extremely aggressive, North Carolina is one of them, in enforcing the ban on educational malpractice suits by any name. I think of these as a little bit like a kind of New York Times versus Sullivan defamation landscape. There's a First Amendment principle that is being infused into the state action that would otherwise occur if courts recognized these lawsuits. If a court recognized a lawsuit that said my online education that my University of Miami, and by the way, University of Miami is the object of 4 of these lawsuits pending before Judge Singal. So the University of Miami or the other schools represented here didn't deliver on the education. The quality of my online education was not as good. There's an almost separation of church and state notion that courts should not make an inquiry into the quality of educational service delivery. A notion that stems both negatively from the notion that courts are incompetent to make these judgments and affirmatively from the notion that universities need to have academic freedom in order to serve their social role. and that has a kind of First Amendment background principle behind it. These cases, of course, as everyone here who's done academic freedom cases knows, got a lot of their articulation during the McCarthy era in cases where what universities were doing in asserting in academic freedom, or what individual professors were doing in asserting academic freedom, is trying to keep the coercive power of the state from drumming out left-wing professors under un-American activities kinds of inquiries. The 1957 case of Sweezy versus New Hampshire, plurality decision was on due process grounds, but the famous Frankfurter concurrence articulated the kind of canonical statement of academic freedom, since the concurrence was on First Amendment grounds, that the 4 essential freedoms of a university are to determine for itself on academic grounds who may teach, what may be taught, how it shall be taught, and who may be admitted to study. Now, of course, Sweezy, which was about interrogating economist Paul Sweezy before a kind of state un-American activities committee, that was about determining who may teach and what may be taught. Later, of course, in Grutter and the other cases upholding the power of universities to provide race preferences in law school admissions, that was about who may be admitted to study. But these new cases implicate the 3rd of the 4 essential freedoms, how it shall be taught. And what I want to leave you with is the sense that the topic of this panel, how it shall be taught, the innovations being talked about, the economic implications that Dean Baines opened with for how this teaching shall be done, I think we all who have been privileged to work in the academic environment start from this cocooned sense that these decisions are ours to make. They should not be subject to scrutiny by legislatures or by ICE. It was our privilege to represent Johns Hopkins University in the suit against, one of the 2 suits against the new policy that would have said foreign students will lose their visa privileges unless they take 1 in-person class. That was quickly withdrawn. But we've lived in the, protected by this notion that academic freedom and its kind of common law embodiments makes these our decisions to make. But what will happen now that this transformative moment has come, and if we start doing the things that Len and Michael and Glenn and Charlton have all talked about so in such a fascinating way on this panel, will that open us up to scrutiny that will no longer be protected by this academic freedom cocoon? Will it focus on the unbundling of core curriculum from other services? So I want to suggest a kind of, to end on an upbeat note, a sort of answer to that notion. The notion, I think academic freedom properly embraces a great deal more than the freedom to teach certain things in the classroom. You can see quasi-academic freedom notions in cases about career counseling. Back when Fair versus Rumsfeld was about, went to the Supreme Court on the question of whether universities could bar military recruiters so long as they discriminated against gay students, there was a notion, I wrote a brief for the American University of University professors suggesting that it was an extension of Sweezy against New Hampshire to see academic freedom as applying to career counseling. In the case of Martinez, Christian Legal Society against Martinez, the University of California at Hastings Law School case that said the law school could refuse privileges to a student group that excluded gay students advocating gay marriage. That case implied that even as to the student activity world, there was an academic freedom notion in a law school deciding what things should go on there. So I want to suggest that academic freedom as embodied in common law notions like educational malpractice is a robust notion. It's one we should support, it's one we should defend, and it's one that we should see as extending beyond the classroom to many other activities that are the rest of Glenn's dinner party. The career counseling, the student services, the networking, the opportunities that we provide through student activities and optional activities like moot courts. The challenge will be how to make sure that we're articulating the importance of those things to our mission. And I think as we develop online substitutes, as we've discussed here, it's very important to show how all these other things that students are claiming they aren't getting through an online education actually can be delivered in a substitute way, and one that we should be the judges of, university administrators, professors, and administrators, and that should not be something that we turn over to the civil courts. So that's what we're arguing in the lawsuit. Full disclosure that I take this position as an advocate, but I also believe it very much in my heart as a former academic. Thank you very much.
Well, thank you. I want you as my lawyer. All right, so we have not nearly as much time left as we hoped, but we have 11 questions. I'll see what I can do here. So some of them are comments. Ana Martinez Escalona, who seems to be a very big fan of online instruction, reminds us, A, that medical schools have been doing online things for a lot longer than law schools and have been good with it, and that B, Mitchell Hamline in Minnesota has a hybrid JD program, and Syracuse now has an online ABA approved JD program, and she was just to look at those to see to what extent those programs rule out nonsense, high school level behaviors, etc. All right, Charlton, you have two questions for you. One from Mira, who's interested, Mira Dio, who's interested in knowing how you plan to assess the success of your program, and another from Jocelyn Hardwick, who's interested in knowing just the name of your program, how she can learn more about it, because she's thinking of doing a similar thing at Cooley.
Oh, so it was just the Miami Law Summer Legal Academy. I think that assessment of the program for us at the moment has been simply forms with the students. Given the quickness with which we sort of built the program, I don't think we had very many commitments about what success would mean, right? Meaning enrollment numbers, application numbers, and the like. I think that students who decide not to go to law school, we will consider a success as much as anything else, right? That students simply get a better sense of what it means to be a law student than anything else. And so we're still thinking about that.
Okay, Glenn, Benjamin Davis and Lisa Rotter have some questions for you. Ben is interested in whether or not in 0L you talk about Duncan Kennedy's reproduction of hierarchy approach, and whether you talk about hierarchies within law school in terms of tracking and what summer jobs are available. And Lisa Rotter wants to know to what extent do you encourage students not just to pick out the details, but also take notes, prepare outlines, and highlight or underline important information inside the cases.
Great. To Ben, we actually have an entire unit taught by David Wilkins on the demographics and the sociology of the legal profession, where we try to highlight, for example, gaps in gender and race at the top of the profession and some of the reasons for that. So, and to Lisa, we try to do a very light touch on the briefing. So in this session, we say something like, here's one way to brief. There are many other ways. You might like multicolor highlighters. You might like to do this. All things that matter is what works for you. We're just going to give you a tiny bit of an attempt to do this for one case, with the thought, again, that our view is we should be passing the torch on to individual law schools rather than being didactic about how people should do something.
Cool. All right, Kathleen, Ben Davis also refers you to a case, Ada Sipple versus the University of Oklahoma, which you may already know about, having to do with a plaintiff who argued about separate but equal with respect to a law school that was segregated. And so the Black woman student was taught in the state capitol by herself and argued that that was not separate but equal, which was certainly not equal. And he's also interested in to what extent you think that the government's role in accentuating and not dealing with the pandemic should in some way affect the university's responsibilities in the further breach of contract.
Sure. So the Sipwell case obviously was cognizable because the reason why Ada Sipwell was being educated alone was purely by virtue of race. And I don't think anything I've said about academic freedom would override the importance of striking down that kind of race-based segregation. That's not something that's defensible in pedagogical terms. It was, so I don't think it alters the argument that where there are otherwise race neutral or gender neutral approaches to substitute education, there might be reasons for deference to the university, but it's a wonderful question. It highlights that there may sometimes be times to challenge university pedagogical decisions where they violate other constitutional values. As to the government role, some universities might seek to assert a kind of impossibility defense that in light of government failure to provide other forms of pandemic relief, then universities are forced to do things that they might not do left to their own devices. This is not without precedent. There have been plenty of times when classes were canceled, for example, because of hurricanes or other natural disasters after Katrina. A lot of students in New Orleans were relocated to other schools, and all the kinds of lawsuits that were brought to say, hey, I didn't get my same education because I was transferred to another school. Those lawsuits tended to fail for the same reasons I described before, and I think properly so. So I think government failure here is something that could be factored into the story of either substantial performance or kind of impossibility defense.
Excuse me, Richard Marsh writes in that maybe we all should consider, going back to the last panel, writing a white paper to coach students on how to do virtual backgrounds that make them all seem uniform and professional. That seems like an idea. And Anna Martinez Escalona wrote back to just let us know that she's a U of Miami law grad and a member for the Sylvester Comprehensive Cancer Center and the Bascom Eye Institute. So that's cool. I'm sure Tony would be particularly interested in that. Okay, so it's 3:25 right now, which I think was supposed to be our formal ending date. And I don't want to, or time, I don't want to take away from the break. So if the people who are managing the tech have this under control, Hakeem, that means you. I want to thank everybody very much for participating. I really enjoyed it, and I look forward to the subsequent panels. And take care, everybody.